hearing. I'm going to go ahead and open up public hearing for both items, the zoning and the CDMP. And I'm going to go ahead and start with the public first, and then I'll call up the applicants too, as it's custom. I said it earlier, as I call your name, please line up through the hall. The first two come up to the first two podiums. And again, you will have 1 minute to speak. You got to state your name and address and confirm the item you're speaking on, which should be 3E, 3E supplement, 3E1, or 8C8. But now is the time to speak on any of those items, which is all one big item. Jackie de Basa, José de Basa, Greta Torrechila, José de Basa the third, La Portia Sturdivant, Pablo Urguelles, Nora Cooper, Vitautas Ramunas, Evia Ramunas, Robert Ball, Alex Duyum, Ken Forbes, Yuleri Castro, Luis Ramos Reyes, Patricia Forbes, Francois Sham, Ruth Sanchez, Gladys Ramos, Gabriel Garcia, Alexis Santos, Omara Martinez, Olga Orduz, Celia Suarez, Alexandri Duyon, and Gabriel Garcia. If you didn't hear your name, I still have plenty on the list, but that's the first batch. If you did not hear your name, I still have plenty on the list. Would you like to get started, ma'am?
Yes, sorry.
No, you're good.
Good morning. I'm Jacqueline de Basa, and I reside at 15350 Southwest 268th Street, directly across the proposed development, and I am against this development. The proposed development not only threatens the fabric of the neighborhood composed of single-family ranch-style homes on builders' acres, accessed by 2 single-lane roads and landlocked into a canal to the north. Multiple neighbors would have to give up over 5,000 square feet of the front lawn or the property for road expansion, not only causing their properties to lose value, but also would be non-conforming. The entire 268th Street is lined with mature oaks and other native trees that house an abundance of native life. Bulldozing through these properties will have an irreparable damage to established ecosystem. The cost of this development is not justified. This project is far from progress, but rather irresponsible and un-American. If you look at this room today and the binders provided with the signed petitions of over 2,500 people that have been verified, you can witness the strong opposition for Bluenest and Naranja.
Thank you so much, and good morning, by the way.
Good morning.
Good morning. Good morning, sir. Please state your name and your address for the record.
Waiting for a PowerPoint presentation that I have.
Okay, did you submit it?
I did submit it, sir.
Okay.
And it was verified that they received it.
All right, well, in the meantime, what we'll do, sir, if you can just step to the side and we'll allow others.
If the PowerPoint is not ready, I'll speak.
Okay.
Thank you, Mr.
You're okay with that, speaking?
I'm okay with that.
Okay. Yes, sir. Please, don't forget your name and your address.
My name is José de Basa, and I live at 15350 Southwest 268th Street, right across the proposed development. And I have a question for you. How would you like to lose over 6,000 square feet of your home, of the front of your home? That is what Bluenest needs to do in order for this project to happen. In order for Bluenest project to be approved, neighbors need to give up part of the front of the home for the road to be broadened. We don't need the road to be broadened at this time. On the last PAB hearing, Horacio Wembe recommended connecting 268 eastbound to US 1, and this broke the PAB tie because we had a tie and the community council denied this proposed plan. But Bluenest has not honored that recommendation. Therefore, homeowners in the community are at risk at losing a major portion of their home. Very un-American.
Jose, let me just stop you 1 second. Please, if we can give the speakers that much respect, I would greatly appreciate it. It's going to go a long way for all of us, and just say thank you so much. Thank you, Jose. Please continue.
Bluenest is not adding any value to our neighborhood. Instead, they're taking away from our neighborhood. If our neighbors lose front of the property, those property will be non-conforming structure, and who's going to pay for the home? And this petition has been verified. All the commissioners have a red binder. Look at the
Jose,
index,
Jose,
please.
Jose.
It's completely verified.
Thank you so much.
Thank you.
Thank you so much. Please. First of all, let me just say good morning to each and every last one of you. Secondly, there's a such thing called decorum in this chamber. Third of all, let me just say this to each and every last one of you. Clapping or making any gestures that make sound, it's prohibited within this chamber. What I would strongly suggest that you do, and it's something that we would be able to recognize and see from here, is you can just snap your, wave in support or.
The board wishes to convert the item to a standard application and transmit. However, if the board takes final action today on the small-scale application, the companion resolution will be deemed withdrawn. These CDMP items also have concurrent zoning applications associated with them, and for each a single public hearing will be held and incorporated into the record as to both the CDMP and zoning items, and this hearing will be conducted in accordance with quasi-judicial principles.
All right.
Item 3E is an ordinance relating to Miami-Dade County Comprehensive Development Master Plan providing disposition of application number CDMP 2024-0016, located on the north side of Southwest 268th Street and east of Southwest 154 Avenue, filed by Bluenest Development LLC in the October 2024 cycle to amend the county's Comprehensive Development Master Plan, providing severability, exclusion from the code, and an effective date. And as noted before, there's a companion resolution to transmit.
All right, we're going to take up the companion item as well. Do you need to read anything when that time comes, or?
The zoning director will read that item.
All right, perfect. Zoning director, do you need to put anything into the record at this time?
Yes, I can read the application number now.
Go ahead.
Application 8C8, Maria del Pilar Villa. Application number Z20240000242. We've had 2,510 protests and 63 waivers of support in this application. There was a 2,510 protests. There was an online petition with protests.
Oh, an online petition.
Most of them are from the online petition. Yeah.
All right. We
Chairman.
should, by the way,
Could we-
let me just, give me a second. Walk me through how these online petitions work, because online petitions, I could live in Canada and sign an online petition. Do you all verify that? Because if that's the case, if online petition is something we measure, then we need to make rules. On those protests, we need to make rules for those online petitions. I think they should be valid, but there needs to be parameters, because you just shook your head that no, you don't verify who's signing these petitions.
We randomly checked some, and you're correct, Commissioner, some were outside of the country. Yes.
You see?
All right, you said the country, not the county. You meant the county. You said the county.
Country. He said the country.
Country. Yeah.
Yeah, so we're gonna disregard the online
So,
stuff. But we have plenty of people here to speak, and we're gonna hear from all of them here today.
Mr. Chairman, if I may, before we included the online petitions, we only had 10 protests.
Okay.
Okay?
All right.
Mr. Chairman, just in the way the information is presented to us, so I would just appreciate
It always
just
gets me. It always
a
gets me.
candid, conversation. If you're going to say that they're all protests, that's fine. But you need to lead with something like, we had 10 protests, that are verified, and 2,500 that are via the internet, and we can't verify. You need to tell us that. We shouldn't have to fish for that information.
And you guys have been doing this long enough and know us that we need this information, that we shouldn't have to fish for this information. But either way, here we are. Are you done with the statement into the record, or?
Yes.
All right. 3A supplement, and 3A1 with its companion item and zoning 8C1. And again, if you or the director needs to read a statement onto the record, now's the appropriate time.
Yes, this is another small-scale CDMP application with a concurrent zoning application. There will be a single public hearing for both of them, and I'll now read the ordinance title. 3A is an ordinance relating to Miami-Dade County Comprehensive Development Master Plan, providing disposition of application number CDMP 2024-0009, located approximately 661 feet north of Southwest 320 Street, between Southwest 197 Avenue and Southwest 192 Avenue, filed by Bluenest Development LLC in the May 2024 cycle to amend the county's Comprehensive Development Master Plan, providing severability, exclusion from the code, and an effective date. And now the director will introduce the zoning item.
Zoning application 8C1, Albert Livingston. Application number Z 2024000119. We've had 90 protests and no waivers of support in this application. Staff provided the board with a revised recommendation, and the recommendation was for approval, subject to the covenant and conceptual plan.
Thank you. And I'm going to go ahead and open up public hearing for this item. But really quickly, and if the answer is yes, I'll do this after this item to the court reporter. Do you need to take a break? Do you need to go to the restroom? You've been sitting there for well over 4 hours. All right. If you need me, just wave me down, and I will take a 5-minute recess so that you can take a break from the little seat. All right. I'm going to go ahead and open up public hearing for both the items. As stated, I have a ton of people registered, and I know that folks are not here because they've left, I think. But I'm going to call every name just to make sure that I don't miss anybody.
Mr.
Or
Chair.
do me a favor. Who said Mr. Chair?
Hello, Mr. Chair.
Yes.
Before we commence, I'd like to request that we are given status of party intervener. My client is a property that's within this comprehensive plan amendment. It's actually included in the amendment itself. So we're not only just an aggrieved party, we're an interested party in this
Who's your client, ma'am, and who are you?
It is, yes, my name is Maria Gralia with offices at 150 West Flagler, and my client is the Miller Trust and Botanics, which is the owner of the property that's included in this application by the county, and therefore we're requesting intervener status.
Okay, good.
And allowed an opportunity to present our case. I've presented a PowerPoint presentation to the county. I've also provided information that is relevant to your review of this application.
Okay, please take a seat and have one of the attorneys could speak to her and then guide me as to what the proper protocol is, if anything different than the normal status. And then we will go there. Abby?
Yes, Mr. Chair. We do not have a procedure for intervener status here in the county. However, some cities do. It is up to the chair, of course, as to how much time to allot the speaker. I think she's describing some specific circumstance that she thinks justifies additional time, but that is at your discretion. We do not have an intervener procedure in our zoning procedures.
Got it, yeah. First time this happens, at least in the last 2.5, 3 years. All right, give me a second. Take a seat for a moment, and I'll call you back up. You said your name was Maria? All right. All right, so I'm going to call everybody's name and treat her as not as an applicant, obviously, but I'm going to treat her as at the end. But let me, or I don't know if this suffices, Madam Attorney, and I want to make sure I cover everybody because the list is long and I don't see that many people in the audience. This is item 3A, 3A supplement 3A1 with its companion item, zoning 8C1. Can you just, by a raise of hands, let me know if you're here to speak on this item? Okay, do me a favor. Everyone with their hands up, just line up on each side of the aisle. And the first two may approach the well. One on each. And you may state your name and address, and you'll have 1 minute to speak. And I know the item you're speaking on at this point.
You ready?
I'm ready for you.
Good morning. Good afternoon. Good afternoon.
Mr. Attorney, back to the previous question about the intervener. Right. Got it.
Yes, Mr. Vice
We're
Chair.
gonna give her 5 minutes at the end.
Okay, that's very good.
That works for you?
Yeah, I just want to say that I have some experts with me, so is it 5 minutes for all of us?
No, it's 5 minutes for the intervener, so you're
Right,
representing
we
the,
are the intervener. So
Right.
I have, we are, this group here that's with me is the intervener. I'm representing them. They're the intervener.
are you gonna, let me
I
just make sure we are on the same page, that's all.
No, absolutely. So
So Maria, let me just
Yes.
get some clarity here. So as the intervener, you're saying the intervener here is a group.
the intervener is my client, and there is information that my client has that's very relevant to this application. There are specific reports that were submitted with this application that are incorrect, and
Okay.
we're here to show.
I think I have a solution.
Okay.
So how many intervener, how
So
many people are
we-
part of your group?
This is our group,
How many? How
Five.
many? 5?
five,
Tell
and
you
then we
what,
also.
all right. So what I'm going to do is I'm going to give you 1 minute apiece, because we were going to give you 5 minutes. That was the agreed upon. So what we'll do is we'll give you 1 minute per person, and that way we can satisfy the issue.
I want to say that we're going to need a.
No.
time.
Well, listen, just trust me on this one. I would never put you in harm's way.
Okay.
What I'm simply saying is to be consistent with everyone else that has appeared before us. We're simply saying if you have five people, we're simply going to break up the 5 minutes, 1 minute per person. Now everybody's on the same standing
And
ground.
we'll dwindle it down to 3 people, and we'll take the 5 minutes, if that's available. And then I also have a PowerPoint presentation that I can quickly go through.
No, as long as you're with it, as long as we can get it over
In 5 minutes.
in 5 minutes.
Okay,
However, how many people you want to
You got
present?
it.
Okay,
Mr.
that
Vice
works.
Chair.
yes, absolutely. And I want to clarify, I do have a PowerPoint presentation. If we can kind of like maybe have some of this, my exhibits shown, it's really going to help.
No,
people.
I understand that. So this is what we'll do. If the media can get the PowerPoint presentation queued up, so when she's ready to speak. So are there any other speakers right now that are left outside of your group? Okay, so we're going to ask you to step to the side 1 moment, please. And then we're going to ask the other speakers to come up and put their remarks on the record, and then we'll move forward.
Mr. Vice Chair.
Point of order, just before we go down the intervener road, maybe we should establish a formal criteria, because what I hear is a young lady who just came up and said she has some people with her and she represents them and that they have important information, and we're deviating from the standard due process. So before we, because we're obligated to maintain a process for everybody that's the same. So we don't have an intervener process, and it's within the discretion of the chair, but be mindful that we may have to do whatever you do for everybody who says the same thing without any proof. Yeah.
Right. So, and I hear you loud and clear, Commissioner Gilbert. But what we're hearing is, they have access to this podium at a right to speak on the item, whether they're interveners or not, if they feel as if they are. So what we'll do is to cover our bases is to simply allow them the opportunity 1 minute to speak and put their name, their information on the record. But we're not going to qualify them as an expert, but simply as someone who's speaking either for or against the item.
So, Mr. Vice Chair, on that point, I only wanted to come up on the specific point of an expert. This county does have specific rules for experts. And to the extent that Ms. Growlia was going to have an expert speak here today, she had a 10-day notification period that she had to comply with, which she has not complied with, and therefore we would be prejudiced by the introduction of any expert testimony on this item. So we would object to that.
No, and let's get back to it. But that's the reason why I said they're not going to be qualified as an expert here, because I haven't heard any predicates that have been laid out that they met a threshold. But what I can do is ask the county attorney to speak as it relates to the expert designation.
So let me just intervene for a second. So I was trying to swallow some lunch back there, but I'm back now. So I see some people standing up to my left. You're right. Yeah, my left. With shirts. Is this part of the expert group, or is this? Or have you all spoken already?
They need to speak.
Okay, so here's what we're gonna do. Unless the attorneys tell me otherwise, we're going to treat everybody as a regular speaker, because we do not have, we have not received notice about this. You can't just show up and expect time to, allocated time. So you have a minute to speak. and everyone will have a minute to speak. That's part of your group. And then if you need to appeal, if you need to file an official motion or briefing with the court, you're welcome to do that. But unfortunately, we do have rules. You had your 10-day window to submit something and a letter of interest at least to come and speak. And at least my office did not receive anything. Did the attorneys receive anything?
I did submit a letter of objection with all our arguments. I also submitted that to every one of you as part of,
When was this submitted?
this was recently, I think it was,
I think it's July 11th,
was the
July
date?
12th.
it was last week that we submitted
But that was
everything.
but that was not an expert witness request.
It wasn't an expert witness request. We can, if you want, I can say, the reason this is really important is that we have people here that understand how the soil percolates and rain percolates, and it's extremely important for your consideration of this application. It is a due process issue.
So here's what
and
I'm gonna do.
in 5 minutes does not take away from their application. It's for your information so that you can make a decision based on correct facts. If I find in their application deficiencies and inaccuracies, it is my responsibility to tell you and your staff that there is a problem and you have to consider it. If you would like, we can defer this to another meeting and I can provide the notice of all the experts that we have.
I'll decide what direction we go in, and this board will decide, not anyone at the well, not even you, Pedro. So here's what we're gonna do. You have I'm gonna give two options, and I'm being very, very courteous right now.
Yes,
Is you either have 5 minutes,
yes.
and I don't care how you distribute that time,
Okay.
or everyone will get a minute. But we're not gonna go on and on and on and on and on. And we are not recognizing it as an expert testimony. This is not an expert anything. This is you speaking just like the applicant is speaking, just like any other speaker that spoke. But because this is a process that is a legal process, you have 5 minutes, but this is not an expert witness type of,
Understood. I just want to make sure that the information we provide is part of the record. I did submit a couple of things to the clerk.
your time is starting. So
okay.
please
All
state
right.
your name and address again, and for the record, and who you represent.
Thank you very much. My name is Maria Graglia, 150 West Flagler Street. I'm here representing the trustee, Jack Miller, as well as Botanics Wholesales. They are the property. If my presentation can be queued up so that you can see what I'm talking about. Oh, here it is. I'm sorry. Okay, so the property that we're talking about is the crisscross, as you can see. So what I want to just make absolutely sure that you all understand that this is, not only is it inconsistent with the comprehensive plan, this board recently had commissioned a report on agricultural lands. And one of the things that you had determined was the value of agricultural lands in this area. This development is going to have a detrimental effect on the agricultural lands. So I ask you to really consider what you're doing here. This is nowhere near the transportation corridor. It is actually over 3 miles away from your smart plan corridor. There is no public transportation from this property over there. The applicant, this is a very different application as the other one that you just approved, which was already had a comprehensive plan amendment to allow for the higher density. This does not have this kind of density. It is mostly agricultural lands. My client has been there for over 40 years. And again, I have submitted into the record certain evidence, the comprehensive plan. I have submitted reports from various industry personnel, and I consider them experts to show why this is incompatible with your comprehensive plan. I have also submitted in the record your report on the importance of agriculture, which was commissioned in 2023. I've submitted those items in the record. At this moment, I'm going to have Mr. Jack Miller speak.
Let's go to slide 9. As mentioned, my name's Jack Miller. I farm the land that's in question for 45 years. I'm intimately aware of it and how it reacts to
Sir, just get closer to the mic, and if you could tell us
Yes,
what
absolutely.
you own.
As I said, I have been farming this land for 45 years. As you look up here on the screen, you'll see the parcels. Those in yellow are the ones we have. That is a Dade County soil survey that shows specifically the soils on site. Next. This is a Miami-Dade County overlay as well, and it shows, if you look, very slow infiltration rate for D, where most of this property is located. The applicant had access to this. This was readily available.
Give me a second, and you only have 2 minutes, but I need to, whatever we do, and Commissioner Gilbert had a point. As I was walking in, I only caught like the tail end of what you were saying is, and I don't mind giving you the last 2 minutes that you have, that the group has to speak,
It'd be
but
wonderful if I had a little more. It's 45 years of my life we're talking about.
and that's why I want to be respectful and allow you to speak. But here's what I have a question of the attorneys for. I understand that the county doesn't have intervener status protocol, but please explain to me, a non-lawyer, what that really is, because to me it seems like they're just concerned neighbors, like everyone else that spoke. Because the applicant in question, the application in question, they don't own that land. They don't have a stake in it. They don't have possession of it. They're not even lessees or leasers of that. Lessees? Renters of that property. So to me, they're just a neighbor with a stake, just like any other neighbor here that spoke for just 1 minute. So please explain to me what intervener status, actually what that definition is. Because what I don't want to do is establish a precedent in this chamber that we've never established before and we've never had. And anyone could come up here and say, we have intervener status, and therefore we need to be allotted extra time. So while it's not so much about the 2 minutes, I'm happy to give them the remainder 2 minutes. It's about establishing a precedent in this county that I'm not going to establish if it is not within our protocol. Can you please explain this to me, Abby?
Yes, Mr. Chair. Mr. Chair, the county does not have an intervener status in our procedures, in our code. So I'm assuming that the speakers are referring to some other procedure, but we do not have anything that exists like that in our code. Historically, when speakers come before this board, sometimes when they have a lawyer and they have a presentation, the commission has given sometimes a few extra minutes to someone who is represented by counsel, but that's in the discretion of the chair. I will say that my understanding is that the attorney's clients, or one of the attorney's clients, owned property that was within the area that was not part of the applicant's application, but was recommended to be added to it by county planning staff. But they have now issued a revised recommendation to not add that land. But so that, I think that revised recommendation was only completed yesterday. So it could be that
you're no longer in the application.
I want you to look at the exhibit that I've just put on there. The green is my client's property. The red is what they're proposing. So even if we're
Point of order.
taken,
Okay, you're not in it. It was excluded. So you're just a neighbor, just like anyone else that spoke for a minute. So I apologize, but if I continue, I have to allow everybody else, rightfully so, 5 minutes. And we're not going to do that. So you can appeal. There's a process. You could have submit to request 5 minutes ahead of time, or 10 minutes or 20 minutes ahead of time. But now that I'm seeing this on the screen, actually your own diagram, you're not part of the application. You're excluded from it.
until yesterday, we were part of the.
Great, but today is today. Yesterday was yesterday, and today you're not part of it.
And I totally understand that, but we're very much affected by the actual application itself.
Thank you so much for your time. I'm not going to engage in back and forth. Appreciate it. Thank you guys for coming out. You had an additional 3 minutes than everybody, 2 minutes than everybody else had. Congratulations, you beat the system for 2 minutes.
Please.
We are next speaker, please. Or
I can't speak.
no, we're done. You had 3 minutes in exchange for 1 minute that everybody else had. Very unfair. And was dishonest with the initial appeal representation. It was very dishonest on the representer's part. The attorney should have been a little bit more honest. You found out just now, but you have it loaded on the PowerPoint? All right. So we're on the record. Let's continue to, well, public hearing is officially closed.
No, there's another speaker.
Is there more speakers? So they just butt in line? Oh, so they just got in line. Okay. All right. Ma'am. Sure. All right. That's all speakers from the public that I have. To the applicant, actually, Commissioner from District 8, can you take lead as being in your district?
Thank you, Mr. Chair. I know we're very tight on time and we're pressed for quorum. So to the applicant, is the presentation similar to the one that you gave last time? Can we incorporate that presentation by reference, or is there something substantially different in this application for us to consider?
So I think they're substantially similar. The only point I would emphasize with respect to this application is that the properties that we're talking about, none of them are designated ag. 98% of the agricultural land within Miami-Dade County are outside of the urban development boundary. And the only point I was going to emphasize as part of my application was going to be the fact that as part of the ag study that was referenced, it was only a requirement for 36,000 acres of agricultural land. We already have 37,000 acres of agricultural land outside of the UDB, where all the land is designated ag and planned for ag. All of these properties are planned for residential, and we've all been talking about the need for workforce housing. So if it's willing to be carried over with respect to the presentation, recognizing the data that I have in there, I can rely upon that data as part of any potential DOA appeal for the land use side. And then from the zoning perspective, I think staff's recommendation is pretty thorough on that item. And so I can rely upon that. Thank you.
Thank you. And to the attorneys, just from a procedural level, can we incorporate his comments from the previous presentation into this one? No, ma'am, to our attorneys.
Yes.
Yes, okay. Thank you, and again, thank you to the residents for coming out. I don't know. Thank you to the residents for coming out both in favor and against, and thank you to my colleagues for sticking around. I know it's been a long day, and I know we have a number of other applications before us. This one is a little different for me. It's different for me because it is geographically located in a different place. Fair enough, right? And so I'm going to incorporate by reference all the comments that I made on the previous application with this one important caveat. I think the density you have here is too high. It's a problem for me. It's too many units. And so I know, and it's important to put on the record for the neighbors that are here, you have a favorable recommendation from the Planning Advisory Board. You have an adopt with changes from the Community Council, and the staff is recommending adoption as is. Am I correct?
Yes, the Community Council recommended transmittal, and the staff recommends adoption. That's correct.
Okay. The flooding is a concern and the density is a concern. So I need you to lower the density on this project. I need you to bring the number of units down to be more characteristic of the surrounding neighborhood. So I know you need to confer with your client or whatever it is that you do, but I'm concerned about.
Commissioner Gilbert.
Thank you, Mr. Chairman, and thank you for yielding for a second to the District Commissioner, Commissioner Quan-Higgins. You know, I'm a little under the weather, and so I might have been hearing wrong, but I've heard this sentiment communicated several times now about services, and the services aren't there, and the roads aren't there, and the parks aren't there, and the sidewalks aren't there. And I appreciate why you all feel that way, right? Because I live in the north part of the county, and we ultimately incorporated because we wanted more things. But one of the things that I found when I became mayor up there was that a lot of the things that we said we wanted were funded through impact fees. And what impact fees are were when people develop things, you use the money from the development to actually do stuff in the community. And so the folks who were running that area previously didn't want development. So because they didn't want development, they didn't have any of the things that were associated with impact fees. And so this is without characterizing the substance of your arguments. I understand those arguments. But sometimes we don't do a good enough job explaining government, explaining why we put things in certain places. There are reasons why you have so many amenities in District 5. There's a lot of development. They go straight up. There are reasons. And so just be cognizant of the fact that not developing anything anytime in those areas means it's very likely that the things that are developed and paid for with impact fees won't get put there. The other thing I would note is that we hear this agricultural argument that I am very sensitive to, and I always want to know, like, who owns the property? Because sometimes when people are before us with property, and you're all saying, no, it ought to be agricultural, and this is the bread basket of America's winter, and I appreciate those things. I appreciate the need, but it's not indentured, farming. We can't make people farm the land. The land's before us, and I'm assuming you all have control or ownership of the land.
You have control of the land.
You have control of the land. That means somebody either wasn't farming it or they didn't want to farm it anymore. So I'm okay with us never taking farmland, land that someone is farming and someone wants to continue to farm and making somebody build housing on it. But you all ought to accept at some point that the people who ever owned that land or whoever owns that land have the same basic rights to their property that you do. So you want to be able to use your property the way you want to be able to use your property. And we establish broader limits. The vice chairman's going to get you. Vice chairman, he owed a charity something.
Yeah, we'll get that charity over to him.
Yeah, it was him right there. I see you. Raise your hand.
Got him.
No, raise your hand. Let everybody see you. It was your phone. So, but sometimes we get caught up in how we want something maintained. Listen, somebody else sold that property. Somebody else wanted to develop that property. And I understand that we can't let their rights control all of yours, but by that same token, we can't let yours control all of theirs. And so when we're sitting up here, we're just sitting as people at the balanced interest. That's what we're doing. We do appreciate your perspective, but we don't have the luxury of singular perspectives. Just wanted to share that. Thank you, Mr. Chairman.
Well, and I would just add, we don't just appreciate it, but I think this board, it's safe to say, and I can't speak for prior commissions that I didn't serve on, but we actually do listen to the people's voice. This commission does. It doesn't mean that we always vote in favor of one particular person that comes or a group of people that come, but this commission, and again, I can't speak for prior, but we actually do listen. And I've seen plenty of times when we voted things down, we've changed things. I mean, we changed one application today, so, but with that, Mr. Gassan, I know that you were speaking, consulting with your clients. Where are we?
Thank you, Mr. Chair. Commissioner of the district, we are willing to do the perimeter of the property. We had heard a variety of neighbors talk about they want to see just single-family homes there. And so as a compromise, what we would be willing to do is on the perimeter of our sites, do all single-family homes instead of townhomes, and that you get into the townhomes as you get into the interior of the sites.
And that will reduce the number of units?
That will reduce the number of units.
Okay. And to the attorneys, is that acceptable on these parcels? I like that idea because it creates a buffer, a visual buffer of single-family homes on the exterior with a different product on the interior.
And just to, I know Abby's going to come with her excellent advice. The one thing I would say is that we currently have a conceptual master plan. That conceptual master plan is tied to the Declaration of Restrictions. What we could do as part of that conceptual master plan, specifically highlight the perimeters that are going to be single-family homes, and note that they're all going to be, it would be modified for single-family homes on the perimeter of the sites as shown on the conceptual master plan.
Just to clarify, in the current conceptual master plan, there's an 8-foot landscape buffer and sidewalk. So would this be inside of that 8-foot?
Yes, yes, it would be in addition to. So we wouldn't. So as part of that, Commissioner, we also were anticipating some of the concerns. So we created an 8-foot instead of a 6-foot sidewalk, and in addition to the 8-foot sidewalk, we're creating an 8-foot landscape buffer between us and the properties. And now we would be doing an additional single-family perimeter on the exterior of the site.
If you can give me just a second just to jot
Absolutely.
something down, and then I think the zoning director may have a question if it's the will of the
Director?
chair.
Yes, Mr. Chair. I think the applicant should identify a lot size for those perimeter properties, okay? What will the lot size be?
RU1?
RU1?
RU1 is 7,500 square feet. There's some RU1 just to the east of this property.
I see that on the map. There's RU1 directly abutting this particular property. I appreciate that proffer. Negotiations and compromises often leave both sides somewhat uneasy, and I think that's what we have here today. But I do think it's a fair compromise, and I appreciate it. So with that, with the amendment to the application that was just proffered, and
Point of order, just 1 second, Mr. Chairman. We need to, we're about to, yeah.
We have quorum without her.
Natalie's leaving too.
Just a
We need-
procedural question. You have an item on today.
Well,
Are
Natalie's
you
not leaving.
comfortable with the item? Would you like us to move forward with your item? I realize you have to leave.
All right, so,
Speak faster.
all right, so the item is moved per staff recommendation and with the amendments.
Second.
And with all the stuff, Abby, that you put into the record and all the stuff.
Can I just say it very, very quickly?
Abby, it's got to be very, very quickly.
Mr. Chair, it's approved per staff recommendation as revised per staff to remove the parcels that had previously been recommended for addition. For the covenant, the addition would be to add language to indicate that inside the landscape buffer and sidewalk, that the perimeter of the site would only have, only single-family homes would be allowed at the perimeter inside. And also with the additional, per RU1 standards, with the addition of the conceptual plan as an exhibit, and with the provision that no multifamily apartments shall be permitted on the property. That was previously in, but I just think it had inadvertently been left off. And that would be with the condition to provide revised, legally sufficient CDMP and zoning covenants with these changes, zoning, joinders, and opinion of title within 10 days, or the application is deemed withdrawn.
All right, it's been moved by Commissioner Cohen-Higgins, it's been seconded by Commissioner Gilbert. Clerk, please call the roll.
Commissioner Higgins? Commissioner Milian Orbis? Commissioner Regalado? Commissioner Bastion? Commissioner Cohen-Higgins?
4.
Commissioner Gilbert? Vice Chairman McGee?
Yes, as following the previous vote, that this is the Commissioner's District, and I'm following her recommendation. Thank you.
Chairman Rodriguez?
I vote yes.
Motion passes unanimously.
Thank you, Commissioner District. Thank you, Chair. Thank you, members of the board.
Thank you very much. And then this doesn't have a companion, right? Is it 8C1?
Does.
All right, so with that, Director, do you need to read anything into the record?
Just wanted to note that it's with our revised recommendation.
Of course it is. Commissioner from District A, you recognize for a motion.
I move the companion zoning item consistent with staff's revised recommendation.
It's been moved by Commissioner Cohen-Higgins, seconded by Commissioner Gilbert. Seeing no further discussion, Clerk, please call the roll.
Commissioner Milian Orbis? Commissioner Regalado? Commissioner Bastion? Commissioner Cohen-Higgins?
4.
Commissioner Gilbert? Commissioner Higgins?
Yes.
Vice Chairman McGee?
Yes.
Chairman Rodriguez?
I vote yes.
Motion passes unanimously.
All right. Congratulations, Mr. Gassan. Madam Attorney, let's take item 8C2, please. And if the Director needs to read anything into the record or yourself, please do it at this time.
Application 8C2, Merrick Park, application number Z2024000147. We've had no protests and no waive of support for this application.
All right. We have